I haven't, of course, reviewed the content. It's just in front of me.
Okay, Mr. Dewan, we're back on the record. You're aware you're still under oath, sir?
Yes, I am, sir. Thank you.
Okay. You can proceed, Mr. Yorio.
Morning, Mr. Dewan. I'm Robert Yorio, representing Captain in this proceeding. Nice to
Good
meet
morning,
you.
Robert. Nice to meet you too.
In your written testimony, you indicate that you are the Chief Technology Officer of Curb Mobility. Is that
That is
correct?
correct. Yes, that is correct.
How long have you held that position?
I think over 10 years now.
Generally speaking, what are your responsibilities as Chief Technology Officer?
I lead all product and engineering at the company.
As you were, oh, we haven't repeated.
All products and engineering.
All
What do you say before?
product management and software engineering, I lead.
I lead.
Could you look at the Exhibit 6? It's the confidential release and settlement agreement that Mr. Shear sent to you.
Yep,
Would you
I'm
turn
looking
to
at
the second page under terms and conditions?
Yeah.
Take a look at paragraph 2, capital B. You see that section about 12.5 cents?
Yeah, I do. Yes, sir, I do.
Okay. In your written testimony, in paragraph 14, you express some concern that an additional revenue stream to Captain would give it an unfair advantage. This draft settlement agreement, if the rate increase is approved, indicates that 12.5 cents of the 50-cent request shall be remitted to any technology service provider using an operator in Clark County. Is that information new to you?
I'm sorry. I'm trying to decipher your question from the preamble. Could you please just ask me the specific question, assuming I
Sure.
understand the preamble?
In paragraph 14 of your written testimony, you say that you're concerned that providing additional revenue stream to Captain would give it an unfair advantage over other technology providers such as Kirk. And Exhibit 10 2B indicates that if approved, 12.5 cents of the 50-cent request would go to any technology service provider selected by an operator in Clark County. Is that news to you?
Yes, it is. I had not seen this exhibit in framing my response.
So if approved by the board, Curb Mobility for operators that it provides technology in Clark County would receive a 12.5 cent share of the 50 cents. Does that change your view about concern that Captain, as opposed to Curb, would have an unfair advantage?
I think that I have a clarifying question on where does the rest of the 37.5% go?
In 2A of the document, if you look at the document that Mr. Shear sent you,
Yeah,
look at
I am looking.
2A, the remainder 37.5 cents goes to IVSC.
Yeah, so I think I think that if you look at my response in isolation of point number 18 in my testimony, you don't have the full picture of my position. If there's a 12-cent technology fee, which is assessed because of the technology burden all technology providers provide, that's a separate discussion, and we should have it and assess what that is in combination with the 37.375, which is basically a arbitrary fee that we are paying somebody, which I don't understand. I feel overall, I go back to my point number 18, it is an unwarranted tax on the customers of Clark County. So if you look at it, if this was about the 12.5% because of all the great things the technology provide, 12.5 cents because of all the things the technology providers do, that's a separate conversation. But it's coupled with the 0.375, which goes with my 0.18, which in that whole combination is my response.
Thank you for that explanation, but I am talking about your statement in item 14, which is about your concern that an unfair advantage would go to Captain as opposed to other technology providers such as Curb, your company. Now that you know that 12.5 cents, if approved, 12.5 cents would go to Curb as well as Captain for operators that it services in Clark County. Does that change your view on 14, not 18, 14?
And I'm trying to tell you that my established position is a combined position of 14 and 18. It's a consolidated view. So I do not look at those two things separately. I think of them as a combined decision because I feel like the meritorious process to determine what would happen with the 12.5%, 12.5 cents for the technology provider is a completely different matter. And when combined, I feel that they go together. So I in my mind, respectfully cannot decouple the two. Because the hypothesis that we've come through is because of the patent infringement. It's not because of the burden the technology providers take.
Okay. So you're unable to separate your statements in paragraph 14 and 18 to answer my question, which is limited to paragraph 14.
Yes, I'm under oath, and I'm trying to tell you in my mental model of my response, the wholeness of the matter at hand comes into play. And I feel that that if this was about a technology fee for technology providers to have for the burden they take, that's a separate conversation altogether.
So you cannot answer my question if I limit it to just paragraph 14, correct?
I actually did answer it, is that I can't because of the coupled nature of it.
Thank you. Going back to your written testimony, which I believe you have in front of you.
Yes, yeah, I do, sir.
In paragraph 5, you indicate that 25 patents are registered, U.S. patents are registered in your name. Is that as an inventor, S&E, or both?
Inventor, sir.
Got it. And you're on the board of a patent holding company that is actively executing a patent monetization strategy? Is that correct?
Is correct, sir. That's correct.
Is that holding company affiliated with Curb Mobility in any way?
No way, zero. It's a company I founded.
And what is the name of the company?
It's called Xstone Networks.
And what field or fields does that company hold patents?
It holds patents in the area of voice assistants and voice services provided to local devices.
And has that company entered into any license agreements with alleged infringers of the technology in those patents?
That I think that's outside the scope of this agreement. It's confidential to the relationship that I have with the patent company by the board member.
We have the ability to designate confidentiality to parts of testimony, if that would allay your concern about that.
I mean, you're asking me about the inner workings of the patent company that I work for, and I feel like without the approval of the board, I can't speak for them.
And what's the relevance here to this particular issue?
Well, if he is familiar with a patent monetization strategy and licensing, I'm not asking for specific license, like who it is or anything, but are you familiar with the process? Has your company entered into a licensing agreement with a third party without divulging the name of the third party?
So I'm going to sustain the objection as to relevance. I think that there's other questions you can ask that don't go delve into what is probably confidential information as a board member and an owner of that company. Also, Mr. Dewan, if you would please spell the name of your company for the court reporter's purposes, please.
XTONE. And I am one of many shareholders. It's not my company. I'm one of many shareholders in that company, and I sit on the board.
As your, in your capacity as a board member, have you participated in licensing discussions with third parties who might be accused of infringement of the patents?
You're asking me about the strategy on how we monetize our patents, and that is confidential. And licensing is not a part of our strategy. Litigation is.
I'm just asking for a yes or no question. Without identifying individual companies, have you participated in licensing discussions with third parties about the patents that are owned by your company? Yes or no?
I'll object.
I'm going to sustain the objection. I think he's answered your question, Mr. York.
Okay.
I think we all know what his stance is.
And I think that's more general.
Yeah.
Is this patent holding company, would you characterize it as a non-practicing entity?
Could you define that for me, please?
A non-practicing entity is a company that holds patents but does not operate a business other than monetization.
Yes, we are actively pursuing only a monetization strategy.
And with respect to identifying companies that your company believes may have infringed the patents, is that a part of the business of the company that you get involved with? Just yes or no?
Could you ask the question a different way? Is it with regards to my role at Xstone? Is that what you're asking?
Yes. Your role with respect to Xstone. Do you get involved in analyzing whether or not a company may or may not infringe the patents?
I lead that process.
You lead it. Okay.
I'm
And,
deeply involved in it.
and can you tell me generally what you do with respect to analyzing whether a third party may or may not infringe the company's patents?
I'm sorry, I'm going to object to scope and relevance. I'm really curious as to where this line of questioning is going.
Well, it goes, I just want to see the witness's background and knowledge about analyzing patents and how they get applied to a particular company. And he's made some statements in his testimony that he talks about his view about whether Curb's technology infringes IVSC patents. So what he has to say about going to that conclusion and what his ordinary course of business, I think, is quite relevant.
I'm going to join the objection. I think you're going to ask about his analysis of those particular patents.
And I'm going to overrule the objection. What I'm going to say is that this is a background session of basically his examination, that sort of thing, and he's allowed to talk about and cross-examine regarding how he has a foundation to provide certain statements in his written testimony. So that's where I'm going. I'm not going to go beyond his or go delve into any specific acts that he does on behalf of his company, as opposed to his testimony in this case regarding Curb. But you're definitely allowed to go into his background, his knowledge, his expertise, if at all, in analyzing patents, that sort of thing. I get, and I understand, I think that's where he's gonna go. If he goes far afield of that, feel free to object again.
So, let me rephrase the question for you in light of Vice Chair's ruling. What is your practice from the team that you lead in analyzing whether a third party may or may not infringe your company's patents?
I get the question. The context starts with the fact that we are the patent owners, and our view is looking at people in the industry that are violating our patents. So we are basically litigating or exploring litigation against potential technologies that infringe our patents. So our view comes from that perspective. It doesn't come from a defender's perspective. And in order to do that, we go through an exhaustive process of looking at all the claims that we have. A patent has two bodies. It has a disclosure and it has claims, along with some diagrams. What we do is we look at all the claims, the independent claims, the claim elements in the independent claims, the dependent claims, and we map them to the art in the field on a line by line, sub-element by sub-element basis to understand what we are, where the violations are on our patent. And once we have that summary of that violation, we then file a very detailed evidence-based litigation filing, which identifies exactly where in our claims do we feel are being violated, by what evidence, by the infringer. So that is the process that we follow. And we create claim charts, we create claims axes, but we do this because our disposition is to litigate again for our intellectual property. So our process is exhaustive because we sort of look at all aspects on which we can basically maximize the return on our potential infringements.
Thank you. You mentioned claim charts as part of what's developed during the process that you just described. Just briefly describe your understanding of what a claim chart is.
Typically, a claim chart is created by a patent owner who effectively maps each claim, the sub-elements of a claim, and the dependent claims to infringing intellectual property. So in the case of, IVSC, that's something they should have done, or I'm sure they've done it, where they have the specifics of where the infringements are against the allowed claims, not against a generalized disclosure. So that's the process of what a claim chart is. And that's created by typically the patent owner to start with, and then folks like us basically review the allegations and then defend against that in that manner.
Now, calling you to your written testimony.
Yeah.
In paragraph 12, you indicate that based on your review of the IVSC patents and your knowledge of Curb's technology, I do not believe that Curb's technology infringes any of the IVSC patents. When did you review the IVSC patents?
We reviewed this. I reviewed this sometime initially this year, and then we went through a process with legal counsel to review the patents also.
With respect to your review of the IVSC patents, did you keep any time records of the amount of time you expended with respect to that endeavor?
No, I didn't keep any time records. I feel, I didn't realize I needed to keep a log of that. No.
Are you able to give me a rough estimate of the time you devoted to that particular endeavor?
The process happened in multiple phases. The first phase happened with me, where I think I might have spent maybe 1.5, 2 man days at the most at doing this. And I came up with my established position before we engaged counsel. And then we went through a council-led process that I was actively involved in that went on for several months with Greenberg Turo, where basically they took my initial guidance and then rolled with it and created a set of details that I reviewed on an ongoing basis. I don't know what the track record of that is. But I spent time going through each and every one of those patents and looking at the independent claims before escalating it to legal and saying, yeah, all right, let's look at this.
And with respect to the results of your review that you just described, was that reduced to written or electronic form in some way?
Yeah, it's whatever it was, it's attorney-client privilege between me and Greenberg Turo.
In terms of, I'm not talking about what you communicated with Greenberg Trauer, the firm. I'm talking about the results of what your analysis showed. Is that in a written or electronic form?
I don't have memory of it, but it's possible that when I communicated the state of what needs to happen with my lawyers or what my assessment or read on the patents is, it is between me and the lawyers in electronic form potentially. I don't recall, but just by guessing on how I operate, it's possible that it is.
And that summary of your initial findings is not produced in this proceeding, correct?
I think yeah, go ahead.
This characterizes the testimony. Did not say that there was in fact a summary other than what was provided to the attorneys, which is client privilege.
I'm going to overrule, but I understand the point of the objection. You can answer, Mr. Dewan.
I'm sorry, the question got cut off. Could you repeat it again?
Could you read the question back to the witness, please?
Question. And that summary of your initial findings is not produced in this proceeding, correct?
Correct. The conclusion is.
Just the conclusion that we see in paragraph 12.
Yeah, it was a deliberate choice.
Right?
Was it what choice?
Deliberate choice, I think. Is that your word, sir?
Yes,
Deliberate choice.
that is.
Thank you. When you did your review, did you analyze every claim of all the 5 issued patents? And I mean independent and dependent claims.
I did. When I did my review, I did, and then with the lawyers, we did it again. Yes.
And did you examine all of the elements of every claim of every patent to compare them against Herb Technology?
I did first pass myself and then again formally with the lawyers. Yeah. And I also compared it with the inconsistencies of the claims with the disclosures, and also did my own quick prior art review of it.
And whatever you did to analyze the claims and the elements, whatever your notes or writings were, you have deliberately elected not to produce them in the proceeding. Is that right?
Objection argumentative. That's called to it. Or their obligation.
So I'm just following up on the witness. He said it was a deliberate decision. Not
Yes,
to
I'm happy to answer that question.
But no, Mr. Dewan, I need to roll on the objection real quick.
Sorry,
so-
apologies. I didn't hear you.
I'm going to sustain the objection. I think the testimony is already.
Thank you, sir. No further question. Ask the witness.
Garrett?
Morning, Mr. Devon. My name
Hi.
is Jessica. I don't know if you can see my face. But I
Yeah,
am from the Attorney General's office. I'm here representing the administrator in this matter. I just have a few questions for you that were not addressed in the pre-filed testimony that you have submitted to your counsel. And if I look back and forth, I apologize, but I'll try my best so you can see my face.
Yes, thank you.
So we're here on a rate matter in front of the Taxi Cab Authority Board. Are you familiar with the elements of a rate case in front of the Taxi Cab Authority Board?
Could you break that up for me a little bit in detail, what you mean by elements, and I'll tell you if I am or not.
So elements are what are required to be shown in order to achieve a certain goal. And I wasn't sure if you're familiar what those elements are in front of the board required for the rate change. If not, I can go over them with you because my questions pertain to those.
Yeah, if you could, please. I don't want to, I don't want to gloss over something that I may know or may not know, but the specifics would help, ma'am.
Okay. So the first element is like, what is the rate amount? Do you know what the rate amount requested is in front of the board at this time?
Is that the 50 cent?
I believe, well, if that's your understanding, it is the 50 cents.
Yeah, yeah. So all I see is the pass-through software license charge of 50 cent. Is that what the rate amount is?
I believe that is the request in front of the board from the original application. There's also a breakdown in the 50 cents. Are you familiar with that breakdown?
Yeah, I was just made aware of that breakdown. Yes, of 12 and a half cents and 37 and a half cents. Yes.
All right. Excellent. Thank you. And then the second element is justification for the requested fee amount. Are you familiar with where the 50 cents may have originated from or why that was part of the original request?
Yes, it's because of a patent license fee.
Okay. Are you familiar with any charts or quantifiable calculations of where that number may have originated from?
Ma'am, I'm not. Typically, a process like this goes through litigation where the court basically ratifies its decision based on a damages model. And this has happened between closed doors, between two business entities. So whatever the rationale they came up with is totally up to their wisdom, and it's not market or ratified by any kind of a damages model at all for me to be able to comment on that.
And to clarify, Curb Mobility is a software provider in taxi cabs currently operating in Clark County. Is that accurate?
That is accurate, ma'am. Yeah.
Prior to this request, has anyone approached you or notified you about requesting this pass-through fee in front of the Taxi Cab Authority Board?
I'm sorry. Could you clarify the question? I mean, for me, all of this is sort of blended together. That started in earlier this year when our CEO came to me and asked me to look at this. So I'm not sure. There may be a separation in your mind, but in my mind, it just seems like one continuous thing, ma'am.
Let me see if I can try to rephrase and break this down. When
Sure.
did you learn? When did you learn about the initial request for the pass-through fee?
I think earlier this year.
When you mean earlier this year, do you mean around January, February?
I would say around the Jan-Feb timeframe. I can look up my emails and get to the specifics. I don't exactly remember when, but it was earlier, much earlier this year at some point. I can answer that question by looking at my emails.
And how are you notified of the pass-through fee request?
I got an email from my CEO saying that he wanted me to look at this, and he informed me in that email.
Are you familiar with how your CEO was informed of the pass-through fee?
I'm not. I mean, I think he's active in the taxi cab industry, and we have customers over there, so there may be many ways of that. I don't know exactly how he found out about it.
Now, going to the third element of what is expected to be reviewed by the board is whether or not the requested rate increase or the rate change is within the public's best interest. Before I dive into that, I kind of want to understand what your definition of public is. So how would you define public?
In the simplest terms, I feel Mrs. Smith that needs to go to a dialysis appointment, or a young mother that needs to drop her children to school and has to do it because the bus service isn't adequate. General people that are using the taxi service that live in the county. And that's where my emphasis, that's what I think the people of the county are, and the rest are basically tourists.
And how would you define public interest?
You know, I feel like, you know, we need to make sure that we make mobility accessible to all people, and public interest is trying to make sure that the costs are kept low and minimized to the extent possible to serve the people of the county.
So with your definition of public interest and coupled with this rate increase, do you think that an additional 50 cents as a pass-through fee is within the public's best interest?
In all my sensibilities, I cannot see it rationalized based on my understanding of where we are. So as a result of that, and point number 18, I have said that it is an unwarranted tax for the customers of Clark County. I stand by that.
No further questions. Thank you.
Mr. Chair?
Couple of items.
Yes, sir.
Mr. Devon, you mentioned, is this the camera that's picking us up?
Yes,
I turn this, see me?
I can see you.
Thank you, Ms. Guerra, for making me aware of that. You mentioned in your response to Mr. Yorio, prior art. Can you explain the importance of the prior art to the patent process?
I mean, I think it all comes part of the litigation process. I mean, our court systems are fantastic in trying to create a structure whereby which the patent owners have a good path to monetizing their patents using the court system. And as a part of the court system process, there's a filing that is made, which basically where the plaintiff sues a defendant, and now the defendant basically has multiple strategies on how he counteracts against the plaintiff, and there are multiple strategies that are used. There is and genuine strategies to determine if the allegations are legitimate or not, and it starts with also doing a prior art search to see if there was art that the patent examiner missed during the awarding of the patent, which would be a very critical part of the process. And then there's an invalidity filing that goes along with that. That's one way of doing it. The other thing is also looking at 101 claims to seeing, you know, is the invention obvious in its nature, and given the sub parts of the invention being generally available in the market, which is very, very, very likely a taxi is a very old domain with many players, small and big. That creates a lot of precedence in the marketplace for obviousness also. So it's prior art and obviousness that go hand in hand. And that's a key part of any defendant strategy, but it all starts with reading the specifics of what the claims are against them, which specifically in this case, no one's seen.
Are you familiar with the Curb's prior systems that it's offered in the taxi cab market?
I'm sorry, did you say prior?
It's systems that it's offered over the years in the taxi market.
Last 10 years that I've been here, yes. Beyond that, it's some knowledge that I have, but I'm not the trusted source.
Mr. Yorio asked you about the 12.5 cents and the settlement agreement saying that would be provided to any technology provider. Are there operators in the Clark County market who use both Captain and Curb systems?
I believe there are, yes.
Do you know how the 12.5 cents would be split between Curb and Captain? If
I'm
both-
sorry, that's beyond the purview of my role at Curb to opine on that.
Can you look at Exhibit 6 again, the settlement agreement?
Yes, I can.
Is there anything in that provision in Section 2B that describes how the 12.5 cent fee would be split between multiple technology providers?
Section, yeah, documents itself. This was not familiar with it prior to today. Say that again?
I was turned the other way. I apologize.
No problem. Objection, the document speaks for itself and witness has not seen it before today. So it's an improper question to ask. It's interpreted.
You asked him questions about it, so I'm going to overrule the objection.
You can
answer. Could you ask the question again one more time, please?
Do you see anything in that section that Mr. Yorio calls your attention to that would describe how the 12.5 cents would be split if a taxi cab operator uses multiple technology providers?
On reading of 2B, I do not.
Thank you. That's all I have.
Ms. Bremser, any questions regarding Mr. Scherer?
Yes.
Or
Well, limited to,
redirect?
this is just limited, Mr. Dual, this is just limited to the testimony that was elicited by everyone today. Nothing independent of what he has testified to. Let's see. Mr. Duan, you mentioned in your testimony that you usually approach this from the perspective of a patent owner. Isn't that correct?
No, I did not say I approached this from the perspective of a patent owner. I was asked what my background was, and in the context of my background, I informed the court that in my background, I had qualified his question that and contextualized it with my background, that in my background, I have operated as a patent owner, which is a much more exhaustive process.
But from that perspective, as a patent owner, your business model is, or your strategy is to push litigation. Isn't that your testimony?
It's the strategy of what the board of a company selects, right? And in the case of my company, that's what they have chosen. It's not my strategy. It's the strategy of the board of the company that I am a part of, the company that I have worked for.
So from the perspective of the board of a patent holder, the strategy is to litigate first. Isn't that your testimony?
This board's strategy, based on the strengths of this company's patent portfolio, is to pursue litigation.
And I believe you also stated that the strategy is to maximize the return on potential infringement. Do you recall that?
I recall that in conjunction of the statement I made, which is understanding the claims chart and the infringement in a detailed way so that we can maximize based on the read what the outcome is. So that it was contextualized.
And you understand that the proceedings here are born from threatened litigation from a patent holder, correct?
Yeah, I mean, yeah, sure, yes.
And if that patent holder would adopt the same strategy that the board that you just referred to sought to litigate first, wouldn't that result in considerable litigation costs for those defendants?
It totally depends, right? I mean, it depends on what the filing is. It depends on what the claim infringements are. It depends on what the scope of the allegation is, and it depends on the read of the patent attorneys that determine what the risk of those patents is to the business. So,
Sure,
so there is no generalized answer to that question, ma'am. I mean, this is a process that dies at nothing, and this is a process that goes to considerable amount. We cannot say that all processes lead to exhaustive expensive. The judge could dismiss it in summary judgment on 101 out of the gate within 6 months in the right kind of court system. So it's totally subjective. That's why we have the legal patent process.
You're talking about the merits of the case. I'm talking about the costs endured and expended just in undertaking the process itself. Do you not agree, as a owner of 25 patents, that patent litigation is arduous and costly?
No, I'm going to overrule.
Patent litigation can be costly, can be very costly, and could be within the span of the defender's ability to defend easily. So,
But respect,
yeah. So I can only
Respect-
speak for Curb. So if you want to ask me the question in the context of Curb, I'm happy to speak to that.
and sir, you anticipated my follow-up. So as you sit here, you really have no personal knowledge or understanding of what it would cost should IVSC force litigation against Captain and the operators that have been utilizing Captain's technology for the last 6+ years, correct?
Ma'am, I did not say that. I said that the cost could be determined by seeing what.
Mr. Dewan, hold on 1 second. Let me rule on the objection. I'm gonna overrule the objection. He clearly has a response. Go ahead,
The
Mr.
answer
Dewan.
to-
You can-
The answer to your question is a function of the filing. It is the plaintiff's job to assert an exhaustive filing based on which the defendants will assess whether the process is exhaustive or not. You're looking for a generalized answer, and in the absence of a very specific allegation, I don't believe in good conscience I can give you a generalized answer, or it's even right in the benefit of the court.
And actually, by you saying that to me, I believe you did answer. You can't provide me an answer whether or not IVSC's threatened patent litigation, should it move forward, would be costly to Captain and the operators, correct? You can only provide your perspective from Curb Mobility.
Without seeing what the infringement is, that's the key part of what I'm saying that you missed out. Without seeing what the allegation is, just saying there's a patent that is issued by the patent office and saying it's infringed without any specifics that anybody could opine on, how can we even know what we're talking about?
You testified that you engaged counsel and went through multiple steps to evaluate these patents, correct?
Right. So out of respect for the participants here and the state of Nevada's engagement in this, we decided to, on our own time, look at these patents from our technology's perspective and how the claims read on our technology. Yes.
So you had enough information to assess the situation, but you don't have enough to provide an understanding of what the litigation would cost?
If you, again, I mentioned to you, you can ask me what Curb thinks. From Curb's perspective, we're very comfortable if you entered into a litigation process with us based on how we read the art. And it's within the span of our ability to defend it easily.
And that's Curb's wherewithal, not Captain, correct?
Captain's not in the mix. We're just looking at, from my perspective, I'm not looking at Captain. I don't work for them. I look at the patent and I look at my company and I look at my art. That's what I'm looking at.
And you understand that Curb is a competitor of Captain, correct?
I do understand that, yes.
And if Captain were to be weakened somehow by this process, Curb would stand to benefit.
If hypothetically that were the case, then any competitor could benefit.
But
But
more particular, sorry, go
Yeah.
ahead.
yeah,
But more-
so go ahead. Sir.
More particularly Curb, because Curb is also in the Clark County market.
We are.
So-
When we wake up in the morning, we don't think about how do we compete against Captain. I mean, we're looking at much bigger players that we compete against, and our product bars are higher compared to what we see in the industry, just to be honest.
So your testimony here is that it's not an objective of Curb to compete with Captain. It's not on the forefront of Curb's business agenda.
As we look at our competitive landscape, we look at everybody, but because we're a national company, right, and we basically sell products nationwide and actually even internationally, so we have a broader span on how we look at competition and what percentage of the market that they hold, and in light of that sort of filtration process, Captain is a player, but it's not one that has all our mind share.
But enough mind share to be an intervener in these proceedings, correct?
We're not, I don't believe we're being an intervener in Captain's proceedings. I believe we're being an intervener in an inappropriately imposed fee on the people of Clark County on a patent that has no specifics that have been provided to anybody. It just, in the interest of the industry, I think that's what we're intervening against, if you would ask me.
And you're aware that Curb was part and parcel to the imposition of a $3 convenience fee for credit card charging.
That's a part of the business engine that I'm not a part of that makes decisions on that. Sorry, I can't speak to that.
But Curb does benefit monetarily from that charge, correct?
I mean, we've got a CEO, we've got our lawyers, you can talk to the business guys. I don't know how the money cuts and flows and what the costs are for me to speak to that. As I mentioned, by my background, I run product and engineering. This is more of a sort of a money monetization question, and I'm not the best guy to answer that.
So when it comes to the $3 fee, convenience fee, you're not able to address that. But on the other hand, when we talk about the 50-cent fee, you are.
Objection.
I think that
Hold on, Mr. Dewan. I'm going to sustain that objection.
I'll withdraw. Thank you.
Nothing further.
Mr. Tillman. I don't mean to point, sorry. I've just gotten in the hole. Ms. Garrett.
No further questions. Thank you.
Mr. Sure, anything else?
Nothing further. Thank you.
Okay. Then I'm going to release the witness. Thank you, or actually, no, Mr. Member Decker has some questions. My apologies.
No, I do not have any questions.
You don't?
Excuse the witness.
Nope. Which screen?
thank you so much for your time.
Hold on, Mr. Dewan, wait. I have a couple of questions. Real
Oh,
quick.
sorry, I'm right here.
Which one do I look at?
The campus service.
It's kind of disconcerting because I don't see his face. Mr. Dewan, did you review any pending applications for IVFC IP LLC?
When you say pending applications, you mean pending patent applications?
Yes, sir.
I don't think I do. I looked at only the issued patents.
Okay. Tell me why you did a patent infringement claims analysis if there wasn't a demand upon Curb.
I was asked by our CEO to give this the attention that I gave. If he hadn't asked me to give it the attention that I gave, then I would not have. So I would defer to this question to his judgment on why he wanted to. I did get the context and along the way on how this is sort of layering into the 50 cent, which is how I kind of got to know about this. But the reason I did that is because my CEO wanted me to take it more seriously, so I took it more seriously.
And that's kind of what I was getting at, Mr. Dewan. Did you do your analysis as a result of the rate fee increase application by Desert Cab?
I did my analysis because what was presented to me is that there's a cause and effect on the rate fee, which people will be subjected to. So, and the cause, because it's an intellectual property based cause, is why I got involved in this. Otherwise, I wouldn't be. If it was like for any other reason, I wouldn't be. And that's why I got involved, because it was a patent. There was a patent aspect to this fee, which is why I got involved.
Okay, and your written testimony, paragraph 13, states at no time has IFSC notified CURB of any alleged infringement of IFSC's patents. Is that still your testimony today, sir?
Yes, I haven't seen anything where we have a letter from IVSC that says that we are infringing these patents, and this is the details of the infringement against these claims accesses. No.
So other than opinions by your counsel, have you received any other opinions as to whether or not CURB's technology infringes upon IVSC's IP's alleged patents?
No, I mean, I am the CTO. I have an engineering team that understands our product very well. I also am well versed with patent law, and in conjunction with a very capable patent firm, I think we were self-sufficient to come to that conclusion.
Okay. That's all I have. Does anybody have any questioning regarding my question?
None.
No. Ms. Guerra?
No further questions.
All right. So, Mr. Dewan, thank you. We can release
Thank
you.
Thank you so much. Bye-bye.
Let's go off the record. We'll take a 5-minute recess while we get ready for our next witness.
Or to sue.
Right?
No, then there's something.
I think it's Mr. Bailey.